Good morning to you all. I am Dr. JP Singh. Today we'll be covering the topic medical law and ethics. Welcome to our channel. We'll be covering the topic in few lectures. Today is first lecture of the series. Medical law and ethics. What are medical ethics? These are the moral principles which guide members of the medical profession in their dealing with each other, their patients, and with the state. So these are the principles which guide the medical profession in their dealing with the state, the patient, and with each other. So they deal mainly with the doctor and the patient relations, right? So medical practice, it has got two major areas of concern. First is the legal aspect, second is the ethical aspect. And covering the legal aspect, these are punishable under IPCs or other existing laws, whereas the ethical aspect, they are not punishable, but the complaint against these may be made to the NMC or the State Medical Council. Then medical etiquettes. Medical etiquettes, these are the conventional laws. Medical etiquettes, they are the conventional laws of courtesy between the members of medical profession, right? These are the conventional laws of courtesy observed between members of the medical profession, and a doctor should behave. They are the conventional laws which guide the doctor in a way that he should behave with his colleagues as he would have them behave with himself, right? So it deals with doctor to doctor, whereas medical ethics, they guide they are the principle which guide the relation between doctor and the patient. The violation of medical etiquettes is non-punishable, whereas the violation of medical ethics is punishable under IPC. Now moving on to the professional misconduct, or known by many other names like infamous conduct or ethical misconduct or ethical negligence or ethical malpractice. You should know all the synonyms of professional misconduct because you may get the question. It is act of a medical man which should be reasonably regarded as disgraceful. Reasonably regarded as disgraceful or dishonorable by his professional person of good repute. That means his act, it has to be measured, or it has to be marked, or it has to be mentioned by another person in the same profession, where he'll say or he'll give his opinion about the conduct of the individual, and the person who is giving the opinion, he should have good repute and competence in that field. So it is generally described by A's, different A's, and the six main A's are association, first, second, advertising, association with the unqualified person who is not qualified enough to be in the medical profession, but you are hiring or you are associated with such person. Then advertising, adultery in regard to the patient, then abortion which should be unlawful, and addiction of any sort, and alcohol consumption while on the job or while in practice, right? Then there is professional secrecy. Initially it was professional, then it is professional secrecy or professional confidentiality. What it mentions, it is a implied term of contract between the doctor and his patient. It is a contract between the doctor and his patient, where the relation of doctor and the patient requires utmost trust, confidence, fidelity, and the honesty. So the relation between the doctor and the patient is based on mainly four factors. First is trust, second is confidence of the patient in the doctor, third is fidelity, and fourth is the honesty of the relation between the doctor and the patient, based on which the patient is telling you all the information which you are asking from him. And it refers to doctor's obligation. There is obligation of the doctor to keep the information secretive regarding patient, what he comes to know in the course of his professional work. Whatever the doctor comes to know while dealing with the patient, it has to be kept as a secret. And information can be divulged if it is required only when patient's consent. If it is not done so, without the consent of the patient, if it is divulged, except for few exceptional cases, it will be taken, the doctor may be taken to court. And the situation where doctor should not reveal, they say should not reveal the condition of the patient is the public press conferences, the information of the patient to the parents, except when the patient is less than 18 years. When it is less than 18 years, it has to be discussed with the patient, parents. But when it is more than 18 years, the patient is more than 18 years, it is not required to be discussed with the parents. Then information to third parties. Third parties in the form of the employer-employee or someone employing an individual and getting the medical done. No information should be revealed even if the third party happens to be near relative, right? Then between husband and wife, it is not essential to discuss the medical history or medical information of husband or wife with each other. Then free treatment. When the case is free treatment provided to the patient like in government hospital. Even then we should not divulge or tell any information of the patient to unconcerned person. In such case, patient has to maintain professional secrecy. Next is information regarding dead person. The consent must be taken from the nearest relative for giving information to anyone. Without the consent, if information is discussed with anyone, it is crime as per the law. Next is reporting in a medical journal. For this also consent is required. Identity of the patient must be hidden. As you have seen in most of the journals, the picture of the patient when printed in the journal, it is covered in some form. And next is post-mortem findings of the patient or the body. Any post-mortem finding should not be revealed to any relative but given to police only. Now it is up to the police to pass on the information to the court or to the relatives. Now the situation where we may tell the information of the patient to someone who is concerned. This is when one party sends another to doctor for examination with specific intent, like recruitment medical. Recruitment medical, where if you are making someone unfit, you have to mention the medical condition by which he is unfit. And the master sends the servant. Employer-employee, the government sends an employee. Like master servant is individual one person to another, and government sends an employee like government is employing someone, initial medical of the individual done, same recruitment phenomena or recruitment process. Then insurance company sends a prospective client to know if he is having life-threatening disease before getting insured, and when person in police custody or under trial prisoner or convicted prisoner. When they are brought to us for examination, we have to write complete information in the document given to us. So these are the situations where we should reveal the condition of the patient, right? Next is the punishment for not maintaining professional secrecy. These are criminal action and the civil action. In criminal action, it is punishable by, it is criminal act and punishable by IPCs 499, and civil action, here we have to pay monetary. So civil action and criminal action may be taken against the doctor if he is telling the information to unconcerned authority. If beyond this, the patient can make a complaint to the State Medical Council or NMC, which can take any disciplinary action depending on the gravity of the situation or gravity of the information given to the unconcerned authority. Then there is privileged communication. So what is privileged communication? It is a statement. It is a statement made upon any subject matter by a doctor to the concerned authority, right? due to his duty to protect the interest of the community or the state. That means for the privilege, for any information to be privileged, it is because of his duty to the interest of community or for the state, and it has to be discussed with the concerned authority. And it is an exception to professional secrecy, right? As in professional secrecy, we are not supposed to tell or discuss the information about the patient, whereas in privileged communication, we are bound by the law to tell the information which we are getting from the patient. And the examples are the infectious disease, if we find any infectious disease in the patient, or any venereal disease, infectious disease like the recent COVID outbreak, it was there. All patients of the COVID, they have to be name and the details of the patient they have to put on the portal, national portal. Venereal disease in between two patients like husband and wife, if someone is suffering from some venereal disease, it has to be discussed or told to the other spouse. And servants and employees. For this, if it is an employee is found to be like colorblind, where he is going to be a driver or a pilot, it has to be discussed, right? Any notifiable disease, if it is found in the patient, it is the statutory duty of to notify the birth, death, and infectious disease to the public health authorities. If there is any suspected crime while dealing with the patient, a doctor finds any suspected crime, then it has to be informed to the police, then patient's own interest. For the safety of the patient, it has to be discussed and divulged. Self-interest. Here, self-interest means both in civil and criminal suits by the patient against the doctor. When the doctor is fighting a case against with the patient, the evidence is in form of information or the knowledge between the patient and the doctor, information exchange. It has to be told to the court. In the negligence suits, when a physician is employed by the opposite party to examine a patient who has filed a suit for negligence, the information acquired is not privileged, right? If some doctor has been called to the court as an expert witness in some other case where he is examining the patient who has filed a case against the doctor, then the examining doctor who has come as a special witness or expert witness, he has to tell all the information which he finds in his examination to the court, right? Then the courts of law, any expert witness when called to the court to examine or to tell the information which he has found in the case sheet by himself, and a doctor can disclose and discuss the medical facts of a case with other doctor or paramedical staff to provide better care to the patient. That means for the benefit of the patient. These are the main conditions for a communication to be privileged. Then paternalism. It is a less known fact where it is acting upon one's own idea of what is best for other person without consulting that person. It is general practice by some physician where they act upon their own idea when they consider an action to be best for the patient, like removing a malignant organ or termination of pregnancy of an unmarried female when the rape is alleged. In such case, if the doctor is terminating the pregnancy without information to the concerned police, right? It has to be informed, concerned police. And the medical legal importance is that paternalism although done in patient's best interest, is illegal. It is illegal and the doctor may be sued under section 350 of IPC or 129 BNS. That means paternalism by the doctor on patient is against the law. Therapeutic privilege. So, therapeutic privilege is not to reveal the patient such part of the information about the illness which the doctor genuinely thinks would lower the patient's morale and the will to live. It is different from paternalism in the sense that the doctor is considering the information not to be revealed to the patient, that part of the information which is likely to lower patient's morale and the will to live. And the reason for exercising therapeutic privilege is though the risk may be too small and non-existent, virtually non-existent. In today's world, Google is available for everyone, right? So if you are telling something to the patient, they'll Google it and go to vast extent whatever you have discussed with the patient, and they'll go till the end to find something damaging which may lower their morale to live, right? So the risk may be too small and virtually non-existent, but explanation may unnecessarily frighten the patient, who is already fearful because of his medical condition and emotionally disturbed, and cause him to change the decision regarding the treatment. So a doctor should take care while telling the information or the facts about the patient which he finds during the examination or some diagnostic procedure. Then prudent patient rule. Prudent patient rule means it is used in two ways. First, imparting information. Second, giving treatment. Prudent patient, it implies that patient must be given such information about the procedure or the side effects and complication as might be required by a reasonable. Prudent means reasonable patient. That means they are able to understand whatever information we are giving to them. A patient should be told or discussed in the language with the facts which he understands, not beyond that. And therapeutic privilege, it extends only as far as the prudent patient rule allows, right? That means we should tell the patient the information only till the point that the patient is able to understand and get what we are trying to tell the patient. And giving treatment, if doctor exercises therapeutic privilege, he must ensure that he is giving so much such a treatment as would be accepted by the reasonable or prudent patient if he genuinely had all the information about the disease. So prudent patient rule, therapeutic privilege is applied with prudent patients for giving information and giving treatment. So paternalism at one end and patient autonomy is at the other end of the treatment, and in between lies the therapeutic privilege. So the therapeutic privilege, it is exercised by the doctor with caution for giving information and for giving treatment. Paternalism, as we have discussed, is illegal, should not be practiced, and the principle of full disclosure. Though patient decision is supreme, but the principle of full disclosure at times comes with some fear in the patient. So the doctor should use the therapeutic privilege to tell the information about the patient by prudent patient rule. Prudent patient rule. Very important rule it is in practice. This is the total thing which we had for you for today's lecture. Next series of lecture will upload soon. If you have any doubt till now, you can write in comments, and please subscribe to the channel and share the lecture. Thank you.